welcome to Zoom with Czarny. I'm Dustin Czarny, Democratic Elections Commissioner for Onondaga County. And this is my interview show where I talk to democracy advocates and candidates for office. This week, I'm talking to Tom Keck. He's a professor at Syracuse University and our area's resident Supreme Court expert. We had a lot of rulings over the last few months. We've had a lot of cases heard and a lot of rulings to come in the next couple of months. But I thought it would be good to talk to Tom right now because of the recent immunity hearing that was happening with Donald Trump last month, and a few other cases that they heard that are just incredibly important. So Tom is an incredible resource, and I'm so happy to have him on. I didn't have a commissioner in car this last week because I screwed up again. I tried to rely on the Wi-Fi on the train. I come back from Albany on Tuesdays this month as I'm trying to wrap up my last push for legislative agenda items. And I just got to remember, I'm either going to do my commissioner in car when I get home from the train trips, or what will more likely then happen is I will record them on my phone and then upload instead of doing a Facebook Live, because it's just not working out otherwise. But that being said, I will do a commissioner card this Tuesday about the absentees in the June primary, as they are going out early next week. So if you want an absentee for the June primary, now's the time to reserve. You can go to onvote.net. That's our new County Board of Elections website, and you can apply for an absentee or early vote by mail there. Speaking of which, we had two big court cases happen yesterday regarding early vote by mail and absentee balloting and the counting thereof. One was in the Third Division Appellate Court, and that affirmed early vote by mail is constitutional. It was constitutional. It was a unanimous victory. This has already been upheld at the Supreme Court level and now upheld at the appellate division level, again, unanimously. The National Republican Committee and the State Republican Committee had been trying to outlaw the newly enacted early vote by mail statute. This is a pretty strong ruling, though it can have one more shot. They can take it to the New York Appeals Court. Each time they've elevated, they've asked for an injunction and they've been denied, and now they have a unanimous ruling against them at the appellate level. So maybe they'll give it up. Probably not. They'll probably go on to the Court of Appeals. But I feel very confident in that piece of legislation surviving the muster of the Court of Appeals, especially with this unanimous verdict. It was not a one-sided verdict at all. And then there was an interesting ruling out of Saratoga County Supreme Court there on a long-awaited, long-delayed court case on a 2021 law. That's how old this is, that allows us to count absentees and now early vote by mail ballots before Election Day. So they're part of our election night returns. As part of that process, the way in which absentee ballots are counted are we have to count them within 4 days of receiving them. Same with early vote by mail now. And also there's no outside objections to these ballots. Well, the judge basically upheld the law except for the challenge issue. This is expected to be appealed by the state, which means there will be an injunction against the order, which means that what we've been doing for the last 5 elections, 3 elections in 2022 and 2 elections in 2023, actually the last 6 elections, because we also did it during the presidential primary, is going to go forward. We're still going to receive absentees and early vote by mails. We're still going to canvass them within 4 days. The rulings at the Board of Elections is going to stand, and those are the ones that are going to be counted and be part of election night proceedings, as long as they're received by the Sunday before the election. So that's that's going to go forward. It's going to probably go up to an appellate ruling and see whether this is that part of the judge's order about the just the objections is going to be ruled. An interesting note on that case. It came down before the forum shopping law got into place, and so they got it into Saratoga County to pick a judge basically, and the first judge had to recuse herself because the law clerk was a GOP committee member and was bragging at a GOP conference about how the judge was going to rule before the case was even ruled on. So then the judge had to recuse herself. It had to go to I think it ended up being the third judge there in Saratoga County because another one before her recused themselves. So this is why that anti-forum shopping bill was such a great bill, because it keeps this type of stuff from happening, from picking courts with small amounts of judges that are highly polarized and highly political, and going to bigger courts to get that first ruling. That being said, for the most part, this first ruling is fine. This challenge portion of the first ruling might present some bad faith actors, but we're going to have to wait for an appellate court ruling on that to see if that's enacted this year. So we'll have to see, but that's it. Now on to my interview with Tom Keck, professor at Syracuse University, our resident expert of the Supreme Court. Please enjoy this interview. Bye-bye. And we're back, and I'm very happy to have my good friend, Professor Keck, Tom Keck of Syracuse University. I've had him on the show many times. He's our resident Supreme Court expert here in Central New York, but also nationally. And, we were going to wait until the end of this Supreme Court term and some rulings that came down that would come down at the end. But there's been so much happening. I'm afraid of waiting until July, because we did have a ruling on a couple of Trump cases, and then now we've had some hearings on the immunity case. So I wanted to bring him in. Professor Keck, thanks so much for coming back on Zoom with Czarny.
Happy to be here.
Well, maybe, right?
Yeah.
Well, I'm always happy to talk to you. Yeah, but I'm quite concerned. The Supreme Court has had some, had the ruling on the Colorado the Colorado insurrection ballot question that they had, but also, took up the immunity argument and seems to be slow walking it. And there just seems to be this 6-3 Trump majority that is doing just about whatever they can to put their finger on the pulse of this election. So I guess let's talk, at least that's my opinion. Let's get right into it. We had a Trump immunity hearing just the other day on his claim of total presidential immunity, which seems to be made up. And also the Trump ballot question, that there was a quick ruling on that last month to overturn the Colorado Supreme Court, which took Trump off the presidential ballot. And I just can't help but see I actually kind of agreed with that first case, but the differences in the ways this Supreme Court is reacting to two different cases. One, in the Colorado case, acting so quickly, and then the immunity case acting with deliberation, I guess is the best way to say that, and so slowly. And both of those actions seem to be favoring Donald Trump as a candidate. I'd like you to get your thoughts on that.
Yeah, and in addition to those two cases, there's also another case involving a January 6th defendant. So not Trump himself, but another January 6th defendant who was charged under the same federal statute that some of the charges against Trump have been filed under. And so that one's directly relevant to Trump's prosecutions too. And so let me say just a word about kind of all those cases as a group, and then we can get into some of the details more if you want. So so here's what we know so far, right? We know that the Supreme Court ruled in favor of Donald Trump in the Colorado ballot case, so that he, despite by all appearances having engaged in insurrection against the United States, Colorado is not allowed to remove him from the ballot under the terms of the 14th Amendment. Um, and that decision was unanimous in terms of the basic outcome, but the court was split pretty sharply, 5-4. It's actually the only case I know of with a 5-4 male-female split, right? So it was the 3 liberal Democratic women plus Justice Amy Coney Barrett on the one side, and the 5 conservative men on the other side. And what the 5 conservative men did that the 4 women did not agree with was not only put Trump back on the ballot in Colorado, but make it essentially impossible for kind of reaching out even further than necessary to make it impossible for Congress to rectify that in any way, right? There's no allowable mechanism for Congress to enforce the 14th Amendment against Trump. Okay, so we know they did that. In the immunity case, we know already that they have slow walked the case, right? Jack Smith asked them in December to expedite it, and they said no. They let it run through the sort of normal process. Then they agreed to hear the appeal and scheduled it for the last day of oral argument on their calendar. And so that's already a victory for Trump, because it's been widely reported that his principal goal with these immunity arguments has just been to delay the trial as much as he can until after the election. So they already put him back on the ballot in Colorado and everywhere else in the country, and they've participated in his so far successful effort to delay most of his trials until after the election. So that's already happened. Based on oral arguments, it also seems likely that they are going to rule at least partly in his favor in the immunity case. They're not going to rule for total presidential immunity. That's a crazy argument. There's no way they're going to adopt that. But they are slowing the trial. They are likely to slow the trial down even more with some instructions to the lower court judges to sort of kind of work out in more detail the parameters of presidential immunity for certain official acts before they proceed with the trial. Okay, we think they're going to do that. Hasn't happened yet, but we think they're going to do that. And in the other case that I mentioned, where a January 6th defendant has challenged federal prosecutors' interpretation of one of the criminal statutes that's been used against like 100 January 6th defendants, including Trump, it sounds from oral arguments like they're going to rule in favor of the defendant in that case too, which would also directly help Trump by relieving him of a couple of the charges that have been filed against him. Again, that hasn't happened yet, but it seems like they're heading in that direction. And the most striking thing about all these cases as a group, right, is that they are about the original meaning of the Constitution from 1787. They are about the meaning of the 14th Amendment, which was enacted in 1868. And they are about the meaning of a federal statute that was enacted in the wake of the Enron scandal, right? So 3 completely different legal texts adopted at completely different times, and somehow all of them, the best interpretation happens to be the one that aids Donald Trump, right? And so that's just like a sign, I think, that for some members of the current Supreme Court, they seem to be bending over backwards to aid Donald Trump's efforts to avoid legal accountability.
So I guess the question is why, right? I mean, besides the obvious, Donald Trump appointed 3 of the 6 members, and then there's also speculation that Thomas and Alito want to retire in the next term, and they want a Donald Trump presidency or a Republican presidency to be able to do that to preserve this 6-3 conservative Supreme Court for generations. But is there any overriding legal precedent that would tie these 3 cases together? Because it seems odd. It seems odd that they acted with such speed in the Colorado ballot case, where there was no real need for that speed. Donald Trump was the only Republican candidate for the primary ballot there. They could have put him on in June. and he would have been on the general election. But they acted in speed there. And again, that's a case I actually almost agree with, right? Because I do, as a democracy advocate, I do have a little worry about um it wasn't an arbitrary decision. I read the decision, I read the evidence. That what the Colorado Supreme Court did was obviously very thoughtful and thorough, but it still wasn't a court of law. It wasn't an impeachment that ruled that he hasn't been charged with the actual crime of insurrection. I mean, it's a hard pill for me to swallow to take him off the ballot on, and having it being a self-enacting amendment. But at the time when they made that ruling, there was this thought that, they're going to rule on this, but they're going to swap the immunity down and send it back because the DC Court of Appeals has been so thorough in their debunking of this presidential immunity claim. But yeah, they did the opposite there in that one. They decided to take this more deliberate approach. And as you said, it looks like they may be sending it back to the district courts to decide which acts are immune, which ones aren't, and and whether that actually has an effect on the material charges that were brought by Jack Smith. It will probably delay the trial till after the election, which is Donald Trump's gambit. Delay till after the election, and then hope he wins so he can, stop any prosecutions by virtue of being president, or, pardon himself or something close to that. Is there anything that ties these two together that gives any logical reason why the court would act the way it did?
Not in terms of legal arguments. I don't think so. Because
And,
again,
why would we have that with the
right,
Supreme Court, right?
right. I mean, so again, there's legal arguments in all three cases, but they are distinct, right? They are about very different legal texts. And so there's no one set of legal arguments that magically makes all three of those texts the proper interpretation of them is the one that Donald Trump wants, right? And so so I think the answer is no. There's no clear and straightforward legal explanation tying them together. And I think the most, whatever Occam's razor, like what's the simplest, straightforward explanation is that some of the justices in the conservative majority are result oriented, right? They are just really trying to act in a way that is most beneficial to Trump. And why are they doing that? Well, some of it's because some of them really support Donald Trump. Some of them, as you mentioned, would like to retire under a Republican presidency. Some of them, even if, like certainly Roberts, and I think Barrett and Kavanaugh are not really Trump supporters, to the best of my knowledge, but they still operate in a kind of conservative information universe where they are so, Alito and Thomas are even worse on this front, but it's true for some of the other conservatives sometimes too. They're hearing the sort of conservative legal and political take on things so regularly and consistently that they are just super skeptical and dubious of liberal Democrats, right? And so, like, even if they wouldn't say in private that they're a fan of Donald Trump, even if they wouldn't say in private that they're going to vote for him or they want him to win, there's so much kind of whataboutism and both sidesism, right? Where they think that, this comes through in the oral arguments sometimes. They think that Biden or Schumer or whoever, Nancy Pelosi, has done stuff just as bad. And, like in the arguments about the case. So the charges filed against this January 6th defendant are about obstruction of an official proceeding. And the law was enacted after the Enron scandal. And clearly the principal purpose of the law was to criminalize like destruction of physical evidence, right? Which Arthur Anderson shredded, thousands of documents or whatever. And so, but the law has two provisions in it, and one explicitly refers to documents, and the other says, or like obstructing an official proceeding in any other way, or something like that, right? And so,
and why would storming the Capitol and trying to actually delay the certification of the presidential election be considered disruptive. That seems
Right.
fine,
Yeah,
right?
like and the text of the statute clearly applies, right? They clearly disrupted the proceeding, but they were literally asking questions during the oral argument. Again, this is mostly Alito and Thomas. But about like what if like a Democratic congresswoman was like holding a sit-in and like delayed vote on legislation for a little while. Like even if sometimes they're like actively supportive of Trump, but even when I wouldn't say that, they are just so bought into the conservative worldview where it's, like Black Lives Matter protests are equivalent to January 6th, or like student protests on campus now are equivalent to January 6th, which in my view is just a false equivalence, but it helps explain how they're looking at the law and reading it in a way that benefits Donald Trump. Yeah.
So, you know, obviously we're very frustrated about the Trump cases, but you mentioned something earlier about, the first time you've seen the male versus female wings of the party come down in the first ballot access case. But I kind of see another one happening here with this Idaho abortion case. This is a case where the Idaho total abortion ban has provisions in it that even for the health of the mother, abortion can't be performed. And there's a federal law that says that you have to protect the health of a patient in an emergency hospital situation. And the Idaho Attorney General is saying, no, our law overrules that. And of course, the Solicitor General was incredibly passionate in her arguments, and one of the most passionate I've seen, as a very, very layman listening to court arguments, and just a tremendous amount of passion there. But it was funny because some of the questioning by Amy Coney Barrett, almost coming to the defense of Sonia, or was it Kagan, or it was one of the other Democrats, where the Idaho attorney was not answering the question, or answering on both sides of the mouth. And she kind of said, "I'm surprised that this is even an issue. Why is it not covered if you're saying it's covered in the legislation?" But then you had your bets, I believe, is what she said. And it kind of looks like another possibility of this female wing of the court. And we don't know where Roberts is going to land on this, because he's always all over the place when it comes to abortion. And there's rumors that he was part of the trying to make a ruling that would have defanged Roe but not eliminated it. But still, he ended up siding with them. But what is there hope for Amy Coney Barrett, or am I just like
Well, I mean, she's extremely conservative, and she's extremely conservative on religious and social issues. And she is an advocate of an originalist approach to interpreting the Constitution, which means trying to interpret it consistently with its original public meaning. And so, she's not going to support results that liberal Democrats like very often. But I do think it's true that of the 6 conservative justices, I think it is true. So far, it's a short sample so far because she hasn't been on the court very long. But my sense is that Justice Barrett is the what's the phrase I want to use? Like the most judge-like, right? The most sort of reliable and reasonable and consistent and like sincere and like sort of good faith trying to interpret the Constitution in a reasonable way. So there's been just like a couple of moments where this has come through. So one is the Colorado ballot case, where she just wrote very briefly, but just sort of castigating her conservative colleagues for reaching out further than was necessary. And it was particularly striking to do it in that case because they had a unanimous result. And you think if you're on the court and you care about the court's institutional legitimacy and prestige and reputation, that where there's like a unanimous bipartisan result available to you, you should go for it, right? Then it looks like the court's acting like a court. and they would win. They were still going to rule in favor of Trump, but that wasn't enough for them. They wanted to reach out even further and kind of rule even more in favor of Trump to kind of foreclose Congress from trying to disqualify Trump from office should he win. And Barrett didn't go along with that. Another thing I'll just flag is, so 2 years ago, when the court overturned Roe, and on consecutive days, the court overturned Roe and upheld a criminal abortion ban from Mississippi, and it struck down a gun control law from New York. And both of those opinions are originalist opinions, where they say they're trying to interpret abortion rights and gun rights as they were originally understood when the Constitution was drafted. But the way that they apply those arguments in those two cases decided on consecutive days is not consistent with each other. And Kagan pointed this out in dissent. She's like, oh, just yesterday we said this, but look, here we're doing this. Which is it? And Coney Barrett, to her credit, I mean, she joined both of those majority opinions, but she wrote a concurring opinion in the gun rights case, just sort of acknowledging a couple of the sort of unresolved, she called them unresolved methodological issues regarding the application of originalism. And she said, I just want to flag that these issues are out there and we haven't decided how to do this yet. And I'm just flagging for lawyers and judges that this is something we're still paying attention to. And I'm going to encourage us to kind of look at it further. And so it's a signal, at least, of some thoughtful effort to apply originalist theories in a neutral and consistent way. Even if you do that, originalist theories as applied by conservative judges are mostly going to lead to conservative results. But it's still better if they are making a good faith effort to do it in a consistent and neutral fashion than if they literally just don't care and they say one thing one day and they say the opposite the next day. That's worse, you know. So yes, I think Barrett, she's very, very conservative. But among the conservative justices so far, she has shown, I think, a real thoughtfulness and sincerity in how she approaches her job.
You know, and we didn't even mention, I should mention that, because I'm also just flabbergasted by the fact that Justice Thomas didn't recuse himself
Sure.
on either the immunity case nor the January 6th defendant case, when there's ample evidence that his wife was at least tangentially involved in some of the planning of the events around January 6th. I guess that's the best way for me to put it without, slandering, I guess. But it seems, it seems like a no-brainer to recuse yourself, and they still would have a 5-4 or 5-3 majority if he did, and most likely get the outcome he did. But there's no accountability, and even though the justices were forced into having some still self-ruling ethics code that they announced earlier this year, it's not really seeming to do anything when it comes to something as egregious as this. And of course, all of the other things around Thomas with his paid trips and basic sponsorship by a billionaire, to remain on the court. And I know you said that when we were talking pre-show, there's some other cases you wanted to talk about, so I don't want to spend too much time on just the Trump cases. But what are you looking for here? What do you think is going to happen in the immunity case and in the January 6th defendant case? We already know what happened in the ballot case. What do you think is going to happen, and when do you think we're going to get rulings on those?
I mean, most of the big cases typically come out towards the end, which is late June, and I think that will for sure be true of the immunity case, because it seems like at least some of the conservative justices are intentionally slow walking it. The other January 6th case might be a more straightforward opinion writing for them, and it could come out a little sooner. It's hard to predict in any reliable way. And on the January 6th defendant case, I think they are going to rule in favor of the defendant in a way that helps Trump. On the immunity case, I think it's more complicated. I think they have like a variety of different options. They're not going to rule in favor of Trump's broad absolute immunity argument, but they may rule that some kinds of official actions taken by the president are immune from criminal prosecution, and then send it back to the lower courts to work that out, how to apply that to Trump's case. And I think that will come down at the end, and it will have the effect of delaying the proceedings further. So yeah, so it's we never know for sure till the decisions come down, but you can get a kind of sense from the oral arguments about which way they're leaning, and most of the time that sense turns out to be reliable. Yeah. And some of the other cases I would just flag, and we can talk about any of them. So there's one abortion case you already mentioned. There's another abortion case involving access to medical abortions. There's a really significant gun rights case.
Yeah, so let's talk about that. What are some other cases out there that you're waiting on? Probably not with joy. You're probably waiting on in fear that, what are some other cases that we're waiting for rulings on that you think can really change our, it can have some major impacts here on our country.
So so there's a lot. It's a term is chock full of big cases, and they won't all come out in a conservative direction, right? That was true last year too, right? Last year there was a voting rights redistricting case from Alabama that came out in a liberal direction. There was the other kind of election law redistricting case from North Carolina that came out in a liberal direction. So it won't be a clean sweep for the conservatives, and part of the reason for that is that as the court kind of moves further in one direction, so in recent years, as the court has moved further rightward, it makes litigants and lower court judges bolder, right? So they try to start kind of pushing the court even further. And so the cases that they start bringing and the decisions that lower courts start making get even more extreme, right? And sometimes they go further than the court's willing to go at this time. So in particular, the Fifth Circuit Court of Appeals, which covers Texas and Arkansas and Louisiana, is currently the most conservative federal appellate court. And the Supreme Court, both last year and this year already, has reversed the Fifth Circuit multiple times, right? So multiple times where the Fifth Circuit issues a conservative decision and our current Supreme Court reverses them because the Fifth Circuit decision goes too far, right? So one of the clearest examples of that this term is going to be the gun rights case, where this is just a super interesting case. I was talking about it in class pretty recently. It's called U.S. versus Rahimi. There is a federal law that says people who are currently subject to a domestic violence restraining order are not allowed to lawfully own firearms. And the Fifth Circuit said that law was unconstitutional, and which is a crazy result, right? And the reason they said,
why would we want to keep people who are convicted of domestic abuse from getting firearms?
People currently subject to a restraining order, right? A judge has issued an order saying that this woman has shown probable cause that her partner or former partner is threatening her, and so I order you not to go anywhere near her house or her place of employment or whatever the order says, currently subject to that order. And the Fifth Circuit says, yeah, but they still have a constitutional right to bear arms. And the reason that the Fifth Circuit issued that decision, well, one is because the Fifth Circuit is the most conservative appellate court in the country, and they're a little bit off the rails. But two is the court's gun rights case from New York 2 years ago, where they adopted this broad originalist approach. They said something new in that case, right? They've said in lots of different cases, including abortion, that if we're trying to decide whether a constitutional right is protected or not, we should look to the original meaning of the Constitution. And so they say abortion's not protected because they didn't originally think it was in there. But in the New York gun case 2 years ago, they said something new and additional. They said not only that, but if we decide that the right is protected, so like the Second Amendment, we do think protects gun rights, then the next originalist step is any restriction on that right that any legislature might try to enact has to be justified with originalist arguments. So you have to find a historical analog, right? Because no constitutional right is absolute, right? There's restrictions on free speech that are allowed. No constitutional right is absolute, but the only kind of restrictions that should be allowed are the kinds that the framers themselves would have accepted. And so then they're asking themselves, would 18th and 19th century people have supported a law that bans people currently subject to a domestic violence restraining order from owning dangerous weapons? And they're like, well, no, but what, like the concept of domestic violence did not exist in the 18th and 19th centuries. It's like a preposterous question, and it's a
Uh,
preposterous result. And so I am quite confident that the current Supreme Court is going to reverse the Fifth Circuit in that case, because that one just goes too far, right? You could see this in the oral arguments. Coney Barrett thought it went too far. Others thought it went too far. But it's a direct result of their own decision in Bruin, and it's like they've painted themselves into a corner, right? So again, not all the decisions are going to come out in a conservative direction. Sometimes conservative lawyers and judges push things further than Coney Barrett or Roberts or Kavanaugh is willing, to stomach, and so it'll be a mixed bag. It'll be a
Speaking
mixed
of
bag.
which, I
Yeah.
made the mistake of opening up Twitter while you were talking, and this is going to air about 9 days later. But the Fifth Circuit, because you mentioned them too many times, Tom. They're like Beetlejuice. That you mentioned them too many times. They just released a ruling striking down the Louisiana new Black congressional district as a racial gerrymander, even though that is the district that the Supreme Court itself just last term ruled had to be created. So as you said, the Fifth District is out of control, and they will eventually be overturned, I'm sure, on this too, but it's going to probably result in another 2 years of not having a second Black majority district in Louisiana, as has happened for the last 4 years. And they'll just continue to do this time and time again until they just don't get, they get their way, apparently. So that's going to be an interesting one next term, I imagine.
Right. And if you think of it from the perspective of the conservative judges on the Fifth Circuit, who are, if we're speaking frankly, right there, some
Please,
of them,
yes, let's speak frankly.
some of them are acting in a like borderline lawless fashion of like repeatedly pushing the law beyond what the Supreme Court has indicated is merited, and repeatedly getting reversed by the Supreme Court. But still, the Supreme Court's time and attention is limited. And so if you're looking for conservative results, if the Fifth Circuit issues 50 conservative decisions, the Supreme Court's not going to have time to review and reverse them all, right? And so some of them are going to stand, and even some of the ones that do get reversed, meanwhile, they're going to stand temporarily and sometimes affect the outcomes of elections and the like when you're talking about district maps. Another set of cases I would just flag that I've been watching closely, and one of these is from the Fifth Circuit as well, or maybe two of them. There's multiple cases at the court right now about free speech and social media. And those ones, again, we don't know exactly what they're going to do with it. We don't know what they're going to say, but those ones have the potential to be quite significant as well. So yeah, there's abortion cases, there's the free speech and social media cases, and then there's multiple cases about regulatory and administrative law. So the power of administrative agencies to issue sort of specific rules that kind of fill in the gaps, fill in the details, and
this is the Chevron doctrine, is what you're
exactly,
talking about, right?
exactly. So Congress passed.
And let's kind of dial into that, because that I'm glad you brought that up, because that's another thing where the Supreme Court in the past, including Thomas, created this Chevron doctrine, which allowed the administrative state to create rules because they're the experts, they're the ones that are in charge. These are usually the EPA, the FDA, these type of scientific based agencies that are coming up with these regulations. But the court has signaled that they're willing to get rid of the Chevron doctrine, saying that the laws have to be implicit in what they meant. There's no interpretation by the administrative state. The only people who could interpret this are the 6 conservative Supreme Court justices, based on the originalist intent of the Constitution created in 1787, and where when the FDA and EPA were not a thing.
Right,
So
exactly. So so the way it's worked ever since the New Deal, right? From the New Deal up through, up through at least the sort of Nixon era when, the big, environmental statutes, the Clean Water Act and the Clean Air Act were enacted in the early 70s, right? The way it always worked is Congress passed, a federal statute that lays out some broad public policy goals, and then it delegates some authority to an administrative agency, right? So the Clean Water Act says we want to protect the health of our nation's waterways, and then they delegate to the EPA. Well, you got the scientists on staff. You study like which chemicals at which concentration, how many parts per million, etc., are harmful to human health or harmful to animal life if they're dumped in our nation's waterways. And you should periodically update those rules and standards based on the best available scientific information, because of course sometimes scientists discover, now mercury is more dangerous than we thought it was, right? So we need to update those standards. That's the way it has worked ever since the New Deal. The Chevron case is a case from the Reagan era, where the court, including the conservative justices, Justice Scalia was not on the court yet, but he was a big fan of the Chevron decision. He praised it in print, and then he actively kind of stuck with it once he joined the court. What Chevron says is, if the agency has adopted a reasonable interpretation of the federal statute, we should defer to it. Right? If there's an out. If we think it's an unreasonable interpretation, they adopted something completely inconsistent with the statute, then the court could step in. But it's just a deferential standard. It's not us, the judges, who get the first shot at it. It's the experts at the agency. They get the first shot at it, and as long as they adopt some reasonable interpretation, we should defer to that. Well, Thomas, as you mentioned, Gorsuch in particular, and now basically all the conservative justices have been chipping away at Chevron, and Gorsuch for sure wants to reverse it altogether. And it's so interesting. It's like what the sort of divide between what the justices say they are doing and what the actual impact of these decisions is really striking. So what they say they are doing, as you mentioned, is adhering to the original constitutional design, where it's the people's elected representatives in Congress who should get to make federal law, and that's the most democratically accountable part of the government, and that's where federal laws should be made. And so if Congress wants regulation of greenhouse gases, Congress has to explicitly say that in a statute. The EPA can't reinterpret a 30 or 50-year-old law and apply it to greenhouse gases. Congress has to actually say it. That's what they say they're doing. But of course, we know, and the justices on the Supreme Court know, that we have a borderline completely dysfunctional Congress, right? That is unable to keep the trains running on time, keep the lights on, right? The current Congress is so polarized and divided that it doesn't pass any major statutes, with a few rare exceptions. And so every time the court overturns an agency regulation and says, oh, sorry, we're kicking this back to Congress, what is actually happening in practice is that the court itself is just having the final word. And so the court claims it's trying to rein in the power of unelected, unaccountable bureaucrats, but it is doing so by expanding the power of unelected, unaccountable judges, who don't even have the expertise. At least the bureaucrats have the relevant scientific expertise. The judges don't know anything about regulating the environment. And so that whole line of decisions, which has been going for several years now and is going to continue with these cases this term, is really troubling, both from a theoretical perspective in terms of the structure of the Constitution, but also from a democratic policy perspective, right? Because they've used this line of argument to strike down environmental regulations and Biden's student loan forgiveness plan and a number of COVID public health regulations. Yeah.
The pre-clearance part of the Voting Rights Act that was thrown out because they said you had to go back and fix the formula. And lo and behold, the Congress has not fixed the formula, for that.
Right.
So, and so that's been out, and now they're taking on Section 5 of the Voting Rights Act. So they've done you know, and then this goes in with the major questions doctrine, which we could probably spend 2 hours on. You know, that made up line of reasoning. You know, this is all part of that, and what it comes down to is the conservative ideology is about as little regulation and as little, um, it, you know, as little uh ability of the government to serve the greater good as possible in a way of, you know, limiting government. And so these rulings benefit the conservative ideology way more than it ever benefits the liberal ideology, because it allows for the status quo, or it allows for big business to run amok, or you know, work against the liberal interests, whereas, like, you know, conservative interests are, you know, held in high regard with of this court, such as abortion rights, and, you know, or destroying abortion rights, or destroying, redistricting plans, or destroying, the voting rights act. I mean, it just, there's so many different things that it just seems like it it is one of the, you know, I still believe that one of the days that will live on in our memory is the death of Ruth Bader Ginsburg, and the absolute generational tilt of this court. You know, even if, you know, a miracle struck tomorrow that one of the conservative justices retired, and a Democratic president was able to put somebody else in there, it's still a remarkably more conservative court. The fact that Kavanaugh took, what's his face's
Kennedy.
Kennedy's place, who was kind of a, you know, a conservative swing, but still a swing vote, you know, and that that the Overton window has just shifted so far to the right with this court that it's going to take multi generations of Democratic presidents and Democratic Congress to and Senate to get these through. So, on that light note, what is there anything we haven't talked about that you wanted to get out there about the Supreme Court? Or
Well,
are we just waiting till July, or, you know, June and July?
I mean, if you bring me back in July to talk about the cases once they've come down, we can obviously hit on what seem to be the most significant ones. But I am just going to put in another plug for people to keep an eye on the free speech and social media cases,
Oh, right.
because those ones are super interesting. We don't have to go into all the details now, but so there's I'll just quickly flag there's 3 different cases that are currently pending. One of them is a conservative challenge alleging that the Biden administration has colluded with the social media companies to basically sort of coerce them into deplatforming conservative content, right? And the other 2 are liberal challenges, or really challenges by the social media companies themselves, to conservative laws enacted in Florida and Texas, where the states of Florida and Texas are trying to prevent the social media companies from deplatforming conservative content. And the reason these cases are so interesting, and I encourage people to keep an eye on them, is that they potentially have significant practical impacts on people, right? Regular people using social media. But they're also interesting because the legal sort of arguments and the legal divides in these cases don't directly match up with the political divides in these cases. And so it is hard to predict exactly what the court is going to do in these cases. And if we have a court that is functioning well and functioning like a court, it has to at least sometimes issue significant rulings with like scrambled coalitional alignments, right? If they're really having a debate about the best understanding of the law, then sometimes it's going to be a mix of liberal conservatives in the majority and a mix of liberals and conservatives in dissent. That has to happen sometimes. And if it never happens, that is a really bad sign of a court that has gone off the deep end and just been captured by one particular coalition. And so I think it might, mostly I'm pretty negative about this court, but I think in these social media cases, the court might figure out some ways to to reach some decisions that aren't just split on partisan lines. We'll see. We'll see. Oh, Dustin, your audio just went out.
You know,
Yeah.
what, 4 years of doing this, and sometimes I still forget to unhit mute. But Tom, it's a pleasure for having you on as always. Not always a pleasure to talk about what's going on, but it is enlightening. Your perspective is calming, and you know, at least we can get the truth out there, and that's something that I'm very grateful for, that you're always willing to come on and talk to us about this. So we will have you on in July, and well, I'll pray that there will be some good news in July at the end of this court. But Tom, thank you very much for coming back on Zoom with Czarny.
Thanks for having me.
And that was my interview with Tom Keck, a Syracuse University professor, an incredible knowledge of the Supreme Court. I thank him so much for coming on. I'll probably have him sometime this summer once some of these new other rulings that we talked about that we're waiting on come down, including Trump's immunity ruling that is expected. It could wait till the end of June, or it could come sometime in the end of May, as they did with the ballot, placement, the Colorado ballot issue. So we'll see if that happens. This week, again, this weekend, weekly wonk. Right now, I have the New York 22 up. The new New York 22, the third version of New York 22 that we've had in the last three congressional elections. Check it out. A lot of great insight there. I was able to get a lot of great data from my friends at the other boards of elections, as well as State Board and New York Redistricting, and you and Dave's Redistricting app. Just, I'm really proud of that one. So go check it out. Coming this weekend, I'll be doing Senate District 50. That's the New York Senate District 50, vacated by John Mannion. Well, it's not vacated. He's in there right now, but he's running for Congress. So it's an open seat, and there is a primary in that. And it's the seat that was the closest election in the last few elections. 10 votes separated it in 2022. So check that out. Commissioner Carr, again, on Tuesday, I'll be talking about absentee balloting in the June primary. Zoom with Czarny next week. I'll be talking to Ben Weisenberg of Citizens Union about the newly introduced amendment to move cities and other judges and other constitutional offices to even year elections. That, you know, we had a lot of talk about the towns that were in the county offices that were moved, and that's happening between 2026 and 2030. Well, and as promised, an amendment had to be put into place, and that was finally put into place by Senator SCOTUS, and will be voted on for their first passage, hopefully this session. And if that's the case, then we could see cities start to move in the beginning of 2030 to 2032, 2034. So check out my interview with him. He's always a great interview as well. Thank you very much. And remember to go to dustinczarny.com to see all that information, all that content, and any election news that I have to share with you. Thank you very much again, and have a wonderful day. Bye-bye.